Good morning, everyone. My name is Sterling Higa, Chairperson of the Authority. I'd like to call to order the March 5th, 2025 public hearing of the Hawaii Community Development Authority. The time is now 9 a.m.
The Hawaii Community Development Authority is holding today's public hearing both virtually on Zoom and in person. The Zoom link details were included in the public hearing notice. Therefore, members of the public are welcome to join us on Zoom or at the physical meeting site at the American Brewery Building, 547 Queen Street, second floor boardroom, Honolulu, Hawaii, 96813. The HCDA communications staff is hosting the Zoom portion of this hearing. Once this public hearing begins, everyone will be muted for clearer audio. Board members, if you have any comments or questions, please unmute yourselves to speak. It is important that all individuals clearly state their name each time prior to speaking. This is a public in-person and virtual public hearing, so to prevent any distractions, if you are attending virtually and you are not a board member, staff member, or HCDA's Attorney General, please turn off your video during the meeting. If you are providing verbal public testimony, your name will be called accordingly. If you are attending in person, when your name is called, please come to the front of the room. And if you're attending virtually, you may click the raise hand button to indicate that you wish to testify. Each testifier will then be enabled to unmute their microphone and turn on the video in order to provide testimony. In either case, please clearly state your name and affiliation and proceed with your testimony. Oral testimony will be limited to 3 minutes and will be accepted only on matters directly related to the public hearing subject. If the authority's connection for the remote meeting is lost, the hearing will be recessed until the connection is restored. If the connection cannot be restored within 30 minutes, the hearing will be reconvened on Thursday, March 6, 2025 at 9:00 a.m. at the same physical location and virtual Zoom link as today's hearing. Thank you.
Great. Let the record reflect that the following members are present. Vice Chair Ishii.
Here.
Thank you. Secretary Lidstone.
Here.
Member Miranda Johnson.
Here.
Thank you. Member Anderson is excused. Member Evans. I think Member Evans may be in another meeting, so we'll mark her as excused for now. Member Streitz will be coming up shortly. Member Yamashita.
Here.
Thank you. Member Suji. I think Member Suji is also in another meeting. I'll mark him as excused for now. Member China.
Here.
Thank you. Member Sakota.
Here. Good morning.
Thank you. Member Gordner is on his way up as well. Member Leong.
Here.
Thank you. Member Leip is excused. Member Kabibi.
Here.
Thank you. And Member Yamasaki.
Here.
Thank you. I think it is 11 present, and then it were 10 present, and now 11 and 12 present. So we have 4. Perfect. Individuals from the public who have requested to provide verbal public testimony on the administrative rules are on standby and will be permitted to provide testimony respectively. Ryan, for the legal basis and purpose.
Today's public hearing is being convened under the provisions of Hawaii Revised Statutes, sections 206E-281 to 294, the 99-year leasehold program. 1-28.5, 91-3, 92-41, and 206E-5.6, and Chapter 15-219, Hawaii Administrative Rules, HAR, to consider the following matter. the 99-year leasehold program administrative rules. The proposed administrative rules were presented at the February 5th, 2025 public hearing. A public hearing notice was published in the Honolulu Star Advertiser, Maui News, the Garden Isle, Hawaii Tribune Herald, and West Hawaii Today on Thursday, January 2nd, 2025.
Perfect. And then could I ask all members to please mute your audio for the hearing? And I'll briefly explain our procedures for today's public hearing. First, HCDA staff will present its report. Following that presentation, board members will have an opportunity to ask questions or provide comments. Finally, we will take public testimony in the order that individuals have signed up. Individual comments will be limited to no more than 3 minutes. Only members of the authority will be permitted to ask questions of the public. Since each authority member has or will be given a copy of any written testimony that you may have provided, please refrain from reading your written testimony and instead summarize your comments in the time that you have available. When you are called, the communications staff will unmute your mic, clearly state your name and any organization that you are representing. I will be acting as the presiding officer for this hearing. Are there any questions as to our procedures? Seeing none, we will now begin our proceedings. Mr. Deepak Nupane, Program Specialist 5, will now present the staff report.
Thank you, Chair, and good morning, board members. You have staff report in your packet. I'll just briefly summarize it. I'm not going to go into the background because I already provided that last time and it's there. I'll just point out the changes that were made based on the comments that we received at the last hearing. And also I would like to add that we got some comments back from member sites and we are going to incorporate that in the rule. So I'll just cite that so that we have it on record. So going on the changes, on section 2223-18, just clarity, changes made for clarity. If you go to that page, on paragraph A, it says any may want other real property or properties. So that's a change for clarity, properties. And also, if you go further down in paragraph B3, we added trust corporations, limited liability companies and partnerships to be inclusive so that it takes care of everything. Going down on section 19, owner occupancy, additional language on the requirement and waiver to owner occupancy to provide the basis for the waiver, for the owner to provide the basis of the waiver, and then if there is a time frame for which the waiver is needed to provide the time frame too. On section 32, I guess there's some redundancy in the language in classified section. I don't even know if there's a classified section in the paper these days, so it just says the newspaper. So. Same section on paragraph number 8 for the advertisement, statement that the condominium units will be offered to the buyers through either public lottery or on a first come first served kind of basis, or the order in which the application were provided. So provide that clarity in the ad for the on section 33, because this is, we added mail and email addresses for the application intake. On paragraph D, again for clarity, to provide documentation to HCDA for verification of eligibility. On section 34B, paragraph 1, took out the language deeds and added the language condominium conveyance document. On section 48, for the rights of first refusal to purchase by HCDA, earlier we had tied the formula for purchasing by NCDA and consumer intake. So based on the comment, we are changing it to owner's equivalent rent of primary residence for urban Hawaii, and the formula is there. So that's the change. And because that's closely tied to real estate crop than the general, CPI index. And section 49, we added the provision for an owner being able to purchase another larger unit. And we got a suggestion from member Strikes, and I would like to add that change, and I'm going to read it. The only change there is that purchase of larger or smaller unit, so can go both ways. The person with a large unit can sell the large unit and purchase a smaller unit. And depending on whether the size of the family increases or decreases, so we'll incorporate that change. Section 50, initially, and in terms of this is in the first 5 years, but it goes back to it's saying that it's took out the first 5 years, and for clarity said for five years from the date of purchase, initial purchase. And, section 64 and 60, let me go 63 and cure period. Well, let me go 64 first and then go back to 63. And 64, the penalties for violation of one, initially it was this owner occupancy, we added eligibility too. So that allows for if someone provided misinformation deliberately in the eligibility and we find out later on that becomes a violation and we can go back. And because of that change, we needed a change in the cure period to on 63. So 63 occupancy requirement as well as eligibility. We're going to add that language where it says violation of the owner occupancy or eligibility. On 64 paragraph B, took out the language may and made it more stringent by saying should also. On foreclosure paragraph and section 76, paragraph B, it took out the initial language of foreclosure within 5 years. Take that out, cross that out, so that if there's a foreclosure even after 5 years, and the mortgagee is required to give, the lender is required to give NCDA the notice, and then the ability to purchase the unit before it goes to market, so to speak. On section 77, change the language to the leasehold condominium for the remaining term of the leasehold instead of term not to exceed 99 years, just to provide the clarity that the second resale, it cannot be for another 99 years. It has to be for the remaining term of the lease at that point. So those are the only changes, and I believe member Strides, did I incorporate all your comments?
Yes.
With that, that's the summary of the rules. If members have any questions.
Thank you, Deepak. Members, any questions on the staff report? Being no questions from the members, we'll move now to public testimony. Since the notice of the public hearing was published on Thursday, January 2nd, 2025. And also I just want to note that member Suji did arrive at 9:08 a.m. Since the notice of the public hearing was published on Thursday, January 2nd, 2025, and written testimony invited, as of today, the HCDA has received 3 written testimonies, 1 in favor and 2 for comments only. We will now take verbal public testimony. Speakers will be called upon to testify in the order in which they have signed up. Public testimony will be limited to 3 minutes each. Since each authority member has or will be given a copy of any written testimony that you might have provided, please refrain from reading your written testimony and instead summarize your comments in the time that you have available. When you are called, please clearly state your name and any organization that you are representing. The first person signed up is Tower Rojas. Please limit your comments to 3 minutes.
Aloha, can you hear me?
Yes, loud and clear.
Okay, so Tara Rojas, and I'm gonna testify again as the sole oral testifier on February 5th. I again oppose this 99-year leasehold, supposedly low-cost administrative role program. Now, as I heard in the last meeting, and in the previous public hearing meeting last year, August 2024, the 30% units that are slated to be low cost, which does not mean low income, is 400 to 600,000. And the rest are, market costs, which will be more than that. You mentioned that you guys, are targeting the middle class. So again, is this really truly affordable? Is this truly low cost? The fact that the power is, of the people, the power is in the people, and the fact there's a public hearing, and pretty much I was a sole public testifier, because as you mentioned, there's only 3 written testimonies. Tell me, how fair is this process when the one person in favor is the developer that wants to develop with this 99-year leasehold program? The second testifier is a board member, which you are co-volunteers in the National Zoning, the Hawaii chapter of the National Zoning Atlas, in which you look at land use zoning laws. And the third person is a senator who is a chair of housing, who of course is going to support this. So again, I say no, you need to listen to the people. This 3-minute time frame is just a formality, because I've tried before. You said be a part of the process, and I keep speaking to you all, and it seems like you get less and less, give me less opportunity, more focus on just kind of shutting my voice out, which I'm not going to allow. I'm going to keep standing up and fighting for it, because, again, the United States and state of Hawaii knowingly govern over Hawaii lands and resources, property rights under fraudulent legal authority. This is a fraudulent government. You guys do not have the land titles to even be developing and continue to develop, overdevelop unnecessarily. And knowing that sewer costs are going to rise, there's town hall meetings right now, knowing that homeowner insurance costs have risen, that's adding to the mortgage and electricity, not including anything else needed to live in Hawaii. So really, who are you doing this program for? It's definitely not for the people. So again, I just oppose this because—
Please summarize your remarks, Mrs.
yeah, I will
Rojas.
summarize. All U.S. and state of Hawaii land claims and transactions are legally void. So BLNR, U.S. Department of Interior, all of them, you all do not have jurisdiction of the lands that you are planning to build a 99-year leasehold program for.
Okay,
which is
thank
not—
you, Mrs. Rojas.
Mahalo.
I appreciate your testimony. We'll go now to, board members, any questions for Mrs. Rojas? Nope. Okay, we'll move now to testifier Moy Pakiki. Sorry, it's
Hi, can you hear me? Hi, can you hear me?
yes, loud and clear.
Okay, so I style myself as Mo'i. I've represented myself as NLE, which has been notarized by HPD Hawaii Standards Department. So that's why it's officially that way. And Paki is a very important name because that comes from Abner Paki. I am a landholder of a royal patent, the Civil Code number 6539, which was given to my family January 24th, 1992, in the Third Circuit of the state of Hawaii. And as somebody who is a royal patent holder, it is very important, for one, that we understand that, yes, we are illegally occupied. And I just want to make that clear, that everybody in this room understands that these lands are held in a royal patent by another family, which would be a Hawaiian family. Secondly, I oppose this entire construct because a 99-year lease has not worked. We already know that from the development of Department of Hawaiian Homelands. There is so many issues that happen in a 99-year leasehold program. In addition to that, none of us will be there in 99 years. 99 years ago was 1926. Not one person in this room was there. So does that mean that a project that would have been developed in 1926 would be successful today in the current state that we're in? The lands are going to continue to develop. There's going to continue to be issues. How can anybody stand there and say this is going to be a good idea? That 99 years from now, this is going to be a good idea. What year is that going to be? 3024? You can say with 100% certainty that everybody who's going to make a decision today, and the decisions that are being made today are based on development, urban, it says it's a multi-use project, which means that there's going to be rentals there. Blackstone is one of the biggest state and federal developers. And Blackstone has so many issues, one of them being they do things by market value, which means that your rent can increase every year over year. How is that going to help the people of Hawaii stay in Hawaii? That's already an issue, which is at Kapilina Beach Homes. In addition to that, does the developers have any rules and regulations on these low cost units, which I did the math? 260 unit project, 30%, that's 78 units. 182 are going to be sold just regular willy-nilly, who knows, 1 million, 2 million. Those 72 units, are they going to be at the same level of construction as the 182 units? Or are the developers going to be able to use lower cost materials that may not even last 50 years, 10 years, 20 years? These are the things that are happening already in the development projects. In addition to that, there's also been concern over people who buy these low cost units, that they feel they're targeted by the rich people that buy the regular units. So I just wanted to make sure that we as a development is actually thinking in the future, 99 years, instead of making a decision based on your political seats this year.
Thank you, Mo'i. Appreciate your testimony. We'll move, members, any questions for Mo'i? Seeing none, we'll move now to the next testifier signed up. That is Sweet Tea Alana. Sweet Tea?
Aloha. Sorry, wrong screen name. Kalani Kalale Iwi Kauno Hiponi. So I just recently was notified about this HEVA meeting this morning. So I am strongly opposed to this development. My question to you guys is, when you're making these decisions, are you using common sense or are you just looking to profit? Because that's all I see. That's all I hear is profit, profit, profit. Do you guys know that we live on an island? Like, seriously, you realize we live on an island. No matter how much money you spend, no matter how much money you pay for fines, it will never replace our water that will be used to make these developments, that will feed these houses. Really? Do you really think all this money being thrown around is going to help with the water situation? And we know about the water situation. This developer, like my cousin Mo'i was just saying, where will he be in 99 years? He won't be here. I won't be here. None of us will be here. I currently live on Hawaiian Homestead. My 99-year lease is coming up. And they have no clue on what to do when that deadline hits. So any more developments should not even happen. Your little committee, agency, or whatever, you are operating fraudulently and you are an incentivized program. Before you make any decisions, what are you thinking about when you're making these decisions? Are you thinking about your money in your pocket? Or are you thinking about what is going to happen to Hawaii? Who are these low-cost housings going to go to? Because they are not targeted for the people of Hawaii. They are targeted for Haole. And yes, Haole is foreigners. Haole is Americans. Everybody moving into Hawaii is Haole. And all of the people of Hawaii have to move out because of this. So I ask you to use common sense about all these developments you guys want to do. Who are you trying to target? Because it's not the people of Hawaii. 28 seconds. Look at that. And I actually did it. I oppose this. I oppose your agency or department or whatever the hell you guys call yourselves. You guys are all fraudulent, just like Sister Tara said. This entire state of Hawaii corporation is operating fraudulently and it needs to stop. Go ahead. Public law 103-150. Where is the remediation? Where is the reconciliation? There is none. You guys should not be developing anymore, and you guys have no authority over what is to be developed on this land. We, the people, the Kanaka, the ones who hold the royal patent, like my cousin does.
Kalani, could you please summarize your remarks?
Yes, I am opposed. Do not go forth with this development. And like Tara said, it was ridiculous because had we known about this, there would
Okay,
have been
thank you for your
thousands
testimony. Thank you
opposing,
for your-
thousands opposing.
Thank you for your testimony. Okay, thank you to Kalani. We'll now move to the next registered testifier, that is Moleka Hicks.
Aloha, Moleka
Hello.
Hicks. I also oppose this 99-year lease as well as this development. And like you guys heard the last few testifiers say, we are in occupation, guys, okay? You guys represent an entity that is the offspring of the provisional government. Who is the provisional government? They are the offspring of the Committee of Safety. These guys are the ones who are responsible for holding our queen at gunpoint and seizing our government and our kingdom lands. Secondly, you guys work for the agency of the state of Hawaii, right? So the state of Hawaii is actually incorporated in Washington, D.C. You guys are not supposed to have any jurisdiction within the archipelago of Hawaii Pai'aina, okay? You guys are only supposed to exist within the 10-mile radius of Washington, D.C., the District of Columbia. What are you guys doing operating your laws in our country? So I oppose this bill. Not this bill, I oppose this development, and I oppose this 99-year lease. And you guys need to listen and check with the lineal descendants of these lands. You have two on the line right now. You need to actually listen to the concerns of these royal patent holders. And you guys need to also look at the fact that in the near future, before the 99-year lease, you guys will be dealing with major war crimes for these developments. You are not to be constructing any type of developments on occupied lands. You guys are operating outside of your jurisdiction. So please listen to the concerns of those who actually hold the rightful title and jurisdiction to these lands. You guys need to look into the laws of occupation and what laws are supposed to be governing Hawaii Pai'aina. And yeah, that's all I gotta say. I just wanna say that. And so Aole 99-year lease, Aole any type of developments that you guys will try to pursue within these occupied lands, and just do what's pono. You know, Kupuna is watching you guys. You know, there's a shift that's happening right now. And you guys might want to do the right thing going forward. That's all I gotta say.
Thank you, Moleka Hicks. Those are the people who are registered to testify. Is there anyone else on that list? Okay, members, any comments or questions for those who've testified? Otherwise, is there anyone else on Zoom wishing to testify? You could raise your hand if so. Seeing none, is there anyone in person wishing to testify? There is no one in person. So we will now conclude public testimony and move to deliberations and decision-making. Thank you. Members, please indicate yes or no to signify that you are prepared to deliberate. Let the record reflect that the following authority members are prepared to deliberate on the adoption of the 99-year leasehold program administrative rules. Vice Chair Ishii.
Yes.
Thank you, Secretary Lidstone.
Aye.
Thank you, Member Miranda Johnson.
Yes.
Thank you. Member Anderson is excused. Member Evans is also excused. Member Streitz.
Yes.
Thank you. Member Yamashita.
Yes.
Thank you. Member Suji.
Before I say anything, can I ask staff a question at this time of generally about the Kakako area and its development, or is that not appropriate? And the only issue is the rules.
The only issue is the rules at this point, but once we begin deliberations, you can ask staff any questions you have.
Okay, I'm ready. Yes.
Great, thank you. Member China.
Yes.
Thank you. Member Sakota.
Yes.
Thank you. Member Gordner.
Yes.
Thank you. Member Leong.
Yes.
Thank you. Member Lipe is excused. Member Kabibi.
Yes.
Thank you. And Member Yamasaki.
Yes.
I see, is that 13? 13, and we have quorum. So after reviewing the 99-year leasehold program administrative rules, if the, sorry, we can now ask. We can ask questions of the staff before we go to decision making. So members, if you have any questions for staff, now would be the time to ask those questions. Yes, Member Suji.
Just a general question. For staff, I started practicing law in 1989. One of the early cases I had was a condemnation case in Kaka'ako back in probably the 90s. It was over 35 years ago. And I know that, a lot of it, the Kaka'ako lands were actually acquired and were privately owned, that was acquired by the state and now I think owned or held in fee by HCDA. Since that time period, how many affordable home or reserve type home projects has HCDA done? And I understand that I know HHFDC has some presence in that area and have funded both some state-owned lands, but private. But I'm just wondering about HCDA.
So, Member Suji, if I could just ask a clarifying, are you asking how many projects have been done under HCDA's rules, or how many projects HCDA
yes,
has
done by HCDA's projects as compared to another state agency like HHFDC or through financing through HHFDC. But I'm interested in those lands that are under control of HCDA that actually contains an affordable or some kind of reserve type housing project.
So just the HCDA lands?
Yes, I'm curious. For 35 years, yeah.
I can answer that too. Chair Suji, we have a bunch of projects, the Nohona Hale and Cook Street. It's an affordable housing project that's on HCDA land. And it was financed through low-income housing tax credit. And on, I believe, between Waimanu Street and Halekavila Street, we have Art Space, that project, which is an affordable housing project. That's on HCDA land, and that again is a low-income housing tax credit project. We have a third project on Picoy Street. A portion of that project is on HCDA land, not the whole project. The housing is on privately owned land. Portion of the parking garage is on HCDA owned land. And that project, the Hale Kivalo, that project.
Deepak, are these projects leasehold?
Yeah, these are all rental projects.
Right.
So the land is being leased to the developer for 65 years. That's the limit of the lease that HCDA can provide, and all of these
Okay.
leases are nominal leases, basically $1 a year
Right.
lease.
To the developer for in
but-
exchange
yeah.
for developing the affordable home project. And
Yeah.
so
for
today
developing
we'll be voting for to extend the 65 to 99. That's basically what you're asking, right?
Not exactly. The rule is for a new program that was established by the legislature and, the bill, I think it's called Act 97 or Act 97 came up 2023 that provides for a 99-year leasehold program, leasehold condominium program, and provided funding for a pre-development, due diligence and rulemaking and community engagement. So we are in the rulemaking process now, and these rules address only the program that was established in 2023. We had funding, we have engaged a developer, and we are going through the development due diligence, a pre-development due diligence. We haven't selected a site for it. The board needs to select a site. We are creating an inventory of potential sites within Kakako Community Development District as well as outside, because the project can be outside of the district along the transit line. And we'll come back to the board with a list and then the pros and cons of each site before a decision is made.
Okay, thank you.
Thank you, Member Suji. Members, any other comments or questions? Okay, seeing none, I think that we are ready to move toward decision making. So after reviewing the 99-year leasehold program administrative rules, if the board is ready to vote, is there a motion to adopt the 99-year leasehold program administrative rules, subject to any technical, non-substantive comments by the Attorney General and the Legislative Reference Bureau? Do I hear a motion?
I move.
Chair, so moved.
I'll accept Member Yamasaki's movement, and do I hear a second?
Second.
Seconded by Member Gordner. Thank you. Members, any further discussion on this motion? Since there is no further discussion on the motion, I will ask Mr. Deepak Nupane to take a roll call vote.
Remember, the motion been made and seconded on the motion, Member Yamasaki?
Member Yamasaki?
He made the motion.
Yes.
Member Gordner,
Yes.
Vice Chair EC,
Yes.
Secretary Lidston,
Aye.
Member Miranda Johnson,
Yes.
Member Strike,
Yes.
Member Yamashita,
Aye.
Member Suji,
Yes.
Member China,
Yes.
Member Sakura,
Yes.
Member Leon,
Yes.
Member Kabibi,
Yes.
Chair Higa.
Yes.
Vote is 13 years and the motion passes.
Great. Thank you. Seeing no further public testimony, I'll proceed with closing today's hearing. If there are no further comments or discussion, then on behalf of the HCDA authority members and its staff, I thank you for your attendance. The public hearing now stands adjourned. The time is 9:39 a.m. It's okay with everyone. We roll straight to 9:30.